But feel free if you come in with the questions, definitely feel free to send them in into the Q&A right now. We're gonna have a separate second half Q&A sessions with the attorney. We're gonna answer your questions, but we're gonna focus in on H1B, as I mentioned, the key requirements, tips for preparation for next year or the future if you wanted to get H1B. And then we're gonna talk a little bit about benefits and also other details that the H1B holders might get. And the most heated topic right now is the elections and what the future will be with Trump getting reelected. So we're definitely gonna cover that with Adam, that what Trump had historically done to some of the immigration visas, especially H1B visas, and what might his team do in the future. We can only predict. We will never know, but this is something based on, I guess, based on Adam's experience, what we might see in the future. And as I mentioned, we're also going to have a Q&A session. Before we begin today's session, I want to quickly go over who we are as the host of this event. We are GoElite. We're located in Los Angeles. We are a education consultancies. We mainly work with universities that offer CPT, day one CPT, and we are a AARC member, which is a respectful organization in the education industry. And here are two new projects I wanted to announce to everybody. Now we have our own Day One CPT community launched. So if you join this community for free, you are able to stack up on some reward points and exchange that into some rewards. So our team here is going to send those links into the chat. So you can feel free to click the link and check them out. And also we worked on this project for a while. We actually wrote a quote unquote book for F1 students life in the US. So we're going to cover lots of things in this, and this resources is also free. So if you're interested in learning about, visa, housing, healthcare, and stuff like that, definitely also click the link that we're going to share and check out this white book. Okay, so we're also on Google reviews. Feel free to check us out. Lots of students share their own experiences, applying to schools and stuff like that. And we're on all social media, so feel free to follow us. And after today's sessions, we're going to also produce some videos with Adam, and I'm going to share on our LinkedIn, our YouTube, so feel free to check them out as well. All right, without further ado, I'll let Adam take the stage. Let me just stop sharing real quick. Okay.
Everyone, bear with me just a moment. I'm going to share my screen as well. Let's see. It tends to come in and then disappear again.
Yeah, definitely. I was also having some kind of technical difficulties, but here we are. We got it.
Okay. Can you see it okay, Ryan?
Yes, I can see.
Perfect. Okay. All right. Okay, everyone. So I'm so excited to be with you. Thank you, Ryan. Thank you very much again for the invitation. And today we're going to be talking about Trump 2.0. And we don't really know what the future holds exactly, but for those of us who've been in the trenches for the period from 2016 to 2020, the Trump 1.0 term, there's definitely some insights I can offer. And I learned a lot during that administration, and we can kind of learn a lot about what were the priorities at that time. Of course, the COVID pandemic took up the latter part of that administration, and that affected things in a way that we hopefully won't see this time around. But we'll talk a little bit about the H1B process altogether, and then we'll kind of get into a little bit more of, what are some of the trends and the politics involved in it. And I'll just say that, there are many of us in the immigration law community that are here as a resource to help if we can be of any assistance. Don't despair. I know that this is kind of can be a time of turmoil, and I think there's just some fear associated with what a next administration will bring. But we are constantly staying up to date, and I look forward to doing more presentations with Ryan and with GoElite in the future as well. Just to give you a little bit of background about myself, I practice in the academic space and the healthcare space as well. So I work a lot with students, faculty, professors, researchers, physicians, et cetera. And I have a book called The Academic Immigration Handbook, which I have to update every year because things are constantly changing. So I'm working on the fourth edition now, but I imagine it's probably going to change a lot um, after January 20th. So, like I said, we'll talk about the benefits of the H-1B program. We'll give some tips as well, talk about the politics, and then just talk about some other immigration options and day one CPT. I don't want to get too far ahead of myself here because I still really want to get to your questions as well. So we'll try to keep it within about half an hour as well. I always like to start with just talking a little bit about the life cycle for an international student, right? Just depending on where you are, there's different work authorization options and things of that sort. The first 9 months are really mostly for on-campus employment, unless you're eligible possibly for day one CPT, right? Which could be because you're in a graduate program and the opportunity is required by the curriculum, or maybe it's a situation where we don't have the arrow before these first 9 months, but maybe you had another program of study. Maybe you've already accrued a full academic year, and there might be some possibilities to move into CPT right away. The rest of the program is going to be the situation where CPT traditionally comes into play. Special economic hardship work authorization, special student relief can come in certain cases where there's economic hardship, where there is civil unrest in the case of special student relief, civil unrest, disaster, other things that might cause special student relief to be designated and provide work authorization and some flexibility to the full course of study requirements under the F1. There's also pre-completion optional practical training. It's not as widely used as CPT because it directly draws down post-completion OPT, which is something that's very important and very desirable to a lot of students to have that OPT. And then there's internships with international organizations, not widely utilized either. At the time when we get closer to graduation defense date, there is a period there which you all can see during which one needs to apply for OPT. And I would just note, just to be careful about making sure the recommendation for the OPT was entered, was within 30 days of the filing of the OPT. There's basically, it's not evident from the I-20 form that you would receive. And so you always want to be in touch with your university in terms of when they enter the recommendation so you can file the OPT within that 30-day period. Standard post-completion OPT is available for most students. And then we get to the situation where the next steps, maybe you have a STEM degree, science, technology, engineering, mathematics, you might have some OPT, or you might change status to perhaps an H-1B. Might get a green card, might return to school, might go back to your home country. Those are many different sort of next possible steps. Okay, so I want to spend a little time introducing the H-1B. I really love using Canva for PowerPoint, so sometimes I get a little carried away. But the H-1B category is the most common professional worker status, and there was a very interesting July 2019 report that was put out by U.S. Citizenship and Immigration Services, which found during it was like 2008 to 2018 fiscal years. So within that 10-year period, about 89% of F1 students ended up being beneficiaries of the H-1B classification versus 6% in other types of categories, and then another 10% were in non-working categories like dependent categories and things. So the H-1B is very important to international students. And the H-1B is also available across all industries and nationalities. So some non-immigrant statuses are common in specific industries, R1s for clergy, religious workers, for example. Some categories are for particular nationalities, like TN status for Canadian and Mexican nationals. But the H-1B is available to all. It's for professional occupations, those occupations that require at least a bachelor's degree in a specific specialty. And with a green card process underway, you can take an H1B that is commonly limited to a 6 year period, maybe 3 years and 3 years, but you can turn it into a status that can be extended indefinitely in 1 to 3 year increments. Cap exempt H1Bs are very important, and they can overcome the very competitive H1B lottery. So cap exempt, we'll talk a little bit more about those actually, but they're a way around that lottery. And there's no requirement of extraordinary ability for H1Bs. So it's not like an O1 extraordinary ability status. So let's talk a little bit more about the H and the requirements. So as I was mentioning, it is for specialty occupations. So there's a requirement of that the occupation, the position, requires at least a bachelor's degree or higher in a specific specialty. The employee has to have the at least the bachelor's degree, right? They have to otherwise meet the requirements of the position. So if the position actually requires more than a bachelor's, it requires a master's degree. The individual, the H1B worker, has to have at least a master's degree, right, in the indicated specialty, and any required licenses and any required work experience as well. Licenses are very common in education, mostly like K through 12 education, and also in the healthcare sector. There is also a baseline prevailing wage requirement. So the there's an actual wage, or I guess there has to be paid. There's a required wage, is what they call it, and the required wage is the greater of the baseline prevailing wage and the actual wage. The baseline prevailing wage is basically it's determined most commonly by Department of Labor data and statistical surveys that talk about what the wage should be with respect to a particular occupational code category within a particular geographic area. The actual wage is what the employer pays similarly situated workers in the position. So it has to be the greater of that amount, and that is very important, and that can certainly affect the availability of H1Bs if the wage cannot be met by the employer. And of course, an employer sponsors. I already talked about the exceptions for the 6 year limit. It's very important. Oftentimes the H1B runs in tandem with the green card process as a means to keep that individual in status. This is how, for example, Indian nationals who have very extensive, unfortunately, have extensive green card backlogs. This is how they remain in the U.S. and they're able to extend and continue extending their H1B status and work in the U.S. while the green card process is ongoing. The caps, the caps we'll talk about a little bit more, but it's as I was mentioning, the H1B is a very competitive process. There are up to 85,000 numbers that are available each year. There is slightly less than 65,000 available for those who have bachelor's degrees. There's 20,000 that are available for those who have U.S. master's degrees or higher. And you'll see in the next table that's the supply. We'll talk about the demand. Cap exemption is the way around the lottery, as I was mentioning. It's for universities. That's how they get their H's. Nonprofit universities or government universities, not for-profit universities. And nonprofits that are affiliated with universities can get H1Bs via cap exemption, and nonprofit or government research organizations. And it's either that they're employed by these entities or maybe they are placed by a for-profit entity at these nonprofit entities at a university, for example. And that's a way to get around the cap. The current climate is good. We'll see what happens in the next administration. And the pre-registration, so just to kind of back up a little bit about the lottery process, some years ago, it was split into a two-step process where basically you put in your lottery ticket in March to see if you get one of those 85,000 slots available, the employer does rather. And then if the person is selected for the H1B, then they are actually able to put in the full substantive filing. usually around April to June. And so that's how that process is bifurcated. It is also, I should also note that the bachelor's cap is run first for the 65,000 numbers, and then the master's cap is run for the 20,000. So that was changed also. That was changed during the Trump administration to flip the way they run those caps. And what that means is that there are naturally more individuals who have US master's degrees or higher that are selected for cap subject H1Bs every year. So it's something to keep in mind as you are looking into your education plans, that those with master's degrees do fare better in that lottery. As I was mentioning, I was going to show you all a little bit of the demand that's out there. 2025 really says it all. 479,953 registrations for about 85,000 slots. That is much closer to the true economic demand within this country for H1Bs. You'll see this inflated number. You'll see this inflated number in 2024, and that was inflated because there was a lot of fraud that was happening. So, there were employers that were conspiring together to kind of game the system and put in multiple registrations for people. If you have one entity that files multiple registrations for one person, all of those registrations are gone for that individual. But if you have different entities that have different FEINs, they're actually different entities, but maybe they're all part of something much larger, and a plan is made. What was happening was that there were multiple registrations being filed for one person, and it's like one lottery ticket versus 100 lottery tickets. Which would you rather have? But it's fraud. And in this situation, USCIS changed the way the lottery was run earlier this year for the fiscal year 2025 lottery. And now it's one person per passport, right? Like one registration per passport, right? You are your passport. That is your identity. And it's one registration per individual, essentially. So it brought it back down to more natural levels that you see right now, but still very much out of step with the needs of the U.S. economy. Last time I was telling you all about how Tesla hadn't even released its first car yet, and YouTube hadn't. I don't think YouTube was even created at that point. Yeah, YouTube was founded in 2005, which was actually the last time the H1B lottery was touched. So just keep that in mind, how it is sorely out of place with the needs in this country. So let's talk a little bit about the H1B life cycle. So the life cycle starts with, as I mentioned, that registration process. And you can't have any duplicates. And if employer A is filing for you, they can't file for you twice, okay? Or you cannot be registered. So something very important to keep in mind. Not all employers are familiar with how the lottery process works. And so it is good for you to be empowered and have that strong education in how the process works, the mechanics, so that you can bring that back to your employer. And let us know if you need any help. Selection comes after that lottery. That registration happens in March. The selection is usually in early April. And that's when an individual finds out that they have indeed been chosen and made it through that H1B gauntlet. And they have to move on to the filing of the labor condition application. That is something that goes to Department of Labor. It's just certified in typically 7 days, 7 business days. And after that certification, the rest of the H1B can be put together and filed. It's a very substantive packet. One thing I want to tell you all is the cap gap situation that you want to be mindful of. So there's a gap that happens typically, right, between the end of somebody's OPT. Let's say their post-completion OPT ends on April 30th. They cannot start with their cap subject H1B until October 1st. However, if they file the H1B with a change of status request prior to April 30th in this situation, they can get cap gap work authorization extension all the way until the end of September 30th. Okay. And that's a way to bridge the gap up to October 1st. Now, the reason why you want to be mindful of this is because generally if you get selected, you have from April 1st to June 30th, as it's been in past years, to file the H-1B. However, if your OPT is ending earlier, you have until April 30th, right, in that situation, or April 29th, right, to get the filing in if you want to bridge the gap and not have to leave the US for a pretty substantial amount of time. So cap gap, very important. I will also note that um, if if it's not possible, like if the OPT has already ended by the time you can possibly file the H-1B, but maybe you're still in the grace period, you can still file during that grace period and it extends your F1 status, but it does not extend your work authorization, your OPT work authorization. So something to keep in mind. Dealing with requests for evidence, those can come up largely for specialty occupation challenges, but could be for a variety of other types of issues. And so that is a part of the process. And I think we're going to see a lot more of those. There were a lot less during the present Biden administration. The decision then comes, hopefully it's an approval. And if it is with an I-94, if it's approved as a change of status in the US, you get to stay and you have your status here. Otherwise, if you were planning to travel and if it was filed not as a change of status, then you depart the US, you process an H-1B visa, and you come back into the US. And by the way, that would also happen if even if you were approved for a change of status, but then you wanted to leave the US to visit family and you didn't have an H-1B visa in your passport, you would still need to go to an embassy and do the H-1B visa. There's only a few exceptions to that, but you would typically get that H-1B visa and return and resume your H-1B status. Material changes like changes in work locations, um, uh, changes in job duties, decrease in wages can also trigger a need to file an amendment. And then, of course, we talked about extensions and green cards. We've already talked about the cap gap, but if you all have any questions about it, please do put those into the chat. Now, let's talk about Trump 1.0 and maybe some lessons that were learned during that time. So the first thing is if you look at this chart, there's actually a really excellent report that was put out by the Migration Policy Institute, and it's called 4 Years of Profound Change. It's basically charting 472 executive actions that the Trump administration made during the entirety of the administration, right? Trump presidency. And as you can see, some of them were for COVID. There were a lot of immigration enforcement related actions, which is not just the immigration enforcement piece, by the way. Department of Justice is the immigration court system is under DOJ, so that was part of it as well. Humanitarian statuses. These are things that they don't resonate with the Trump administration, in terms of refugees, asylum, temporary protected status, those types of things. I think that there's a lot more traction to be gained in economic-based advocacy and really talking about having conversations about impacts to economy in particular geographic areas of the US and particular industries. But I will say, even being the case, if you'll notice the USCIS and Department of Labor and Department of State, this is the processing that was affected. F1 students, H1B workers, all the alphabet soup of visas, and also green cards as well. So there certainly were effects to the legal immigration system. You can see some of that here represented on the left. And it started with a mission change, right? From us being a nation of immigrants and customer service to protecting Americans to securing the homeland. That was the change in the mission. And when you lead with a national security based sort of analysis, protecting American jobs and things, these are a lot of the types of policies that kind of come from that line of thought. Buy American and Hire American executive order, which really created this culture of denial. And that's when we first started seeing in the early part of the Trump administration, we saw an increase in the H-1B denial rate from 10 all the way up to 21%. And then ultimately, I will note there was a decrease to 13% in the final year. And I think a lot of that was litigation based. There were a lot of lawsuits. And a lot of that was also just a better understanding of how to respond to these types of challenges and requests for evidence and arguments. I mean, there were some fairly crazy requests for evidence trends that really did not, that they were easily challenged because they just didn't comport with the law itself. And so once challenges started being made, legal challenges, just challenges in responding to RFEs, there were some natural decreases. And I don't know what the future holds, and what I'm sure we'll see some unique requests for evidence trends and things of that sort. And I just feel like it made me a better lawyer, that the Trump 1.0, a lot of the things that I thought were bedrock principles of immigration law were really just built on sort of longstanding policy understandings that were very easily dismissed. You know, the Immigration and Nationality Act is a skeletal statutory framework, and there's a lot that the executive branch can do, but then we can also bring in a lot of advocacy efforts, and we can bring in the courts. We can bring in Article 3 court system, right? The judicial branch to try to challenge some of the worst things that happened during the administration.
Adam,
Uh,
sorry to
yes,
jump in. Since you were talking about, in the 1.0,
yes,
stage, some of the H1B are getting denied. Some of the cases or seemed that is not happening right now. Can you give us like an example? Maybe, probably 6 years ago, some cases are getting denied, but it's not getting denied anymore in a similar fashion right now.
sure, sure. Yeah, I mean, I think one of the big ones, really the biggest one, is the specialty occupation challenge, which is kind of, I think you provided me a great transition there, Ryan. So there were basically uh, there was just an increase in these types of challenges, and it is arguing that, um, well, it's arguing a few things that you might have remember how I said it requires a bachelor's degree in a specific specialty. So they could argue that a certain degree was not a specialized degree. I had that for bachelor's in marketing,
Mm.
bachelor's in, or even a master's in business administration. I saw that with some engineering degree, things of that sort. That's one thing, and they would consider them to be general purpose degrees. And one way that we were able to counter that was by showing different concentrations that an individual had. It's not always the case that somebody just has an MBA. They often have a concentration. There was some litigation that said that could make the degree considered to be a specialized degree, right? Like somebody has an MBA, but they have a concentration in management information sciences.
Right.
Another thing that happened were particular occupations were challenged. Computer programmers, computer systems analysts, things of that sort. And I haven't seen the um, same challenges to these particular occupations, right? Another one was where you have a degree, or excuse me, you have a job description, let's say, and the position can require a degree in a few different majors. And maybe the fact that there's multiples of them, maybe the fact that they might seem to be to the officer to be disparate degrees, unrelated degrees, that caused some challenges as well. But a good way to counter that, and there's not as many of those challenges, by the way, but a good way to counter that is with expert letters and other evidence that even though those degrees may seem to be disparate, they all provide the requisite preparation needed to do the job, right? So, like a teacher might have a degree like K through 12, especially, right? Might have, maybe it's a math teacher, high school math teacher. They have a degree in education or they have a degree in mathematics. Okay, they're not related degrees, but they are both helpful degrees to prepare somebody to be a mathematics teacher for high school, right? So those were some of the things that we saw. There were also these level one RFEs that I put over here, which were conflating an entry level wage with something not being a specialty occupation. And you really don't see those very, very often anymore. But there are such things as level one entry level doctors, lawyers, accountants. Like nobody would think that these were, sort of unskilled positions, right? That couldn't be H1B. So that was some of the issues that we saw. How are we doing on time, by the way, Ryan? Are we doing
Oh,
on
we are, I think we are 30 minutes in. We probably still have 5 to 10 minutes
5 to
before
10?
we
Okay,
jump in everybody's question time. And if you do have a question, feel free to send them in so that Adam can answer them for you.
perfect. Thank you, Ryan. So I'll just note just a few other things that happened. Elimination of deference in a lot of these adjudications. So every time you or file them, even if it's the same employer and the same employee in the same situation, there was just considering these applications anew. There were some things that happened. Oh, I want to actually mention the prevailing wage rule. That was another big one that came toward the very end of the administration and ultimately got challenged. But it would have, remember how I was saying how important the wage is, right? For the employer to be able to pay the H-1B wages. That's especially more difficult if you artificially increase those wages and make them unconnected. You sort of put in a certain formula, but you make them unconnected to actual statistical data in the geographic area. And that was what the Trump administration was trying to do at the latter part of Trump 1.0. And that would have made it very difficult for individuals who had, just scaled the H-1B gauntlet and they were selected in the lottery, but then the employer might not be able to pay the wage, given these artificially high wages for, students who are they're in the very beginning of their career, so they're not earning quite as much. So I'm hope that we don't see more of that. I'm certain there will be challenges. There were other things related to unlawful presence for students, and basically any unauthorized activity starts triggering unlawful presence, which can lead to 3 and 10 year bars from the US. And that was ultimately that did not happen, but it's difficult. There's a lot of gray areas in the student world, and this that would have been a very difficult consequence. And more vigilant enforcement of optional practical training, a desire to create a compliance unit, to really look at unemployment accrual for OPT, because you can only accrue so much time before you are rendered out of status for F1. And so there was a lot more digging into that. There were desires to reform CPT and OPT, but they really didn't get very far. So what about Trump 2.0, everyone? So this is a quote that word for word of Donald Trump on a podcast before he got elected president the second time, and it was something that reminiscent actually of a tweet he put out in 2015 as well, before we had one of the most restrictionist, immigration uh, presidencies in a long while, right? So, can you really believe the words, or should you look to the actions that happened between 2016 and 2020? At the same time, and also the audience was a podcast for venture capitalists, and so it was very pro business forces. But I will just say that those forces are out there, pro business, Chamber of Commerce, and Republican governors and Republican mayors, especially in the Midwest. Okay, so there was this was actually interesting to note. Let me see if I can find it for you all. But there was oh, I know. So it was 2024 adopted resolution from the 92nd annual meeting of the U.S. Conference of Mayors. So that's like Republicans, Democrats alike. And the resolution was entitled Endorsing Heartland Visa Pathway for Skilled Immigrants and Immigrant Entrepreneurs in Communities Facing Population Stagnation or Decline. So it's out there. There were some Republican governors that had advocated for an ability for states in the Midwest to be able to directly sponsor immigrants. There are shortfalls of talent, labor, investment in a lot of parts of the country. And I wonder how, impactful those voices might be in the Trump 2.0 term. I'm curious about that. Another thing is Elon Musk, a serial entrepreneur, right? very pro-business individual whose company Tesla filed, I believe it was 2,174 LCAs in fiscal year 2024. A big user of the H-1B program. What will his voice be in this administration? Will it be a moderating force in some way to some of the more restrictionist actions? And what about the Prime Minister Modi effect in India? There are very warm relationships with India, and what might it mean for international student populations? Very large international student population that comes from India, of course, right? And so maybe that will also play a moderating effect to some of the more difficult policies against international students. Remember that I put out that Trump 1.0 slide, but you don't see a lot of that. And it wasn't just because of the Biden administration coming in. A lot of it died right on the vine. It never really crystallized into something. It was more of a proposal or a try, but it didn't make it. There's also thin margins in the House of Representatives, and that will allow for more moderate voices also to be heard. Just like it would allow more radical voices to stop things, it also allows more moderate voices to stop things in the Congress. So I'll just wrap up with talking about some other types of options apart from H-1B, and we'll also look and we'll see how might some of these be influenced. There's O1 extraordinary ability status, and that is often used for scientists, researchers, artists, athletes, performers. It doesn't have any of the prevailing wage requirements or caps. It can be extended indefinitely. O1s currently have a great adjudication rate. And that's a lot in part because of policy memo changes by the Biden administration that really helped provide great clarifying guidance, helpful clarifying guidance. And we'll see if that gets pulled back because it's very easy for the administration to do that. It's very easy to make changes to the policy manual. There were some recent things that Trump had even said on social media about trying to sort of a deterioration of relations between Mexico and Canada and what that might mean for exchange and commerce. And the TN category is part of the U.S.-Mexico-Canada agreement and formerly was part of NAFTA, these trade agreements. So we'll see if there's any impact. The USMCA emerged during the Trump administration, and it left the TN status completely intact. It didn't change it in any way, shape, or form. So it's hard to say whether this would be changed at all. And it's a really good category for Mexican and Canadian nationals. L1 status is transfer. I think in some ways the adjudications got harder. That was a big thing that happened during the Trump administration, but it's basically this is a category that transfers individuals from companies abroad to the US. And it also can be used sometimes where an individual is not selected in the lottery. If it's a big multinational company, they might be able to transfer that student to an office abroad for a year and then bring them back to the US. So we'll see how things might change there. And then finally, J1s, going back to school, F1s, derivative statuses, we'll see. But these are all options, and I don't think many of them changed in too meaningful of a way during the Trump administration. The day one CPT is also was something that was really left pretty much intact. I think just all that we've seen there are challenges with day one CPT where USCIS can sometimes put out requests for evidence where they are aware of day one CPT. They'll put out these requests for evidence just asking about, especially if the student is not living or working, training in the same place as where they're attending university. They might want to know how often they're on campus and, where is how is this directly related to their curriculum? So it's just important to work with, first off, to work with consulting services like GoElite that are aware and do this type of consulting, but also, universities that are familiar with day one CPT, they offer it, but they also provide a lot of support. Maybe they provide letters when there are requests for evidence, right? Because a lot of this is a lack of understanding from USCIS, and a lot of it is what they might perceive as some fraudulent issues, where maybe somebody is actually just using it as a way to work, where it actually can be a very valuable training opportunity as long as it is driven by the curriculum at the particular school. So, oh, and the last thing I'll just say is there are green cards available. There are green card backlogs actually that make green cards not as workable to go directly from OPT to a green card or CPT to a green card. As I've done this plenty of times before, but the backlogs just make it too long. It take quite a while to finalize the green card, and the person runs out of OPT. So that's not those green card backlogs, it's not a Trump thing, it's not a Biden thing. It's just simply an issue where you just have a lot of demand for green card numbers, and you have the same supply, just like with the H1B lottery, same supply you've had since the 90s. So a lot needs to change there, but there are robust green card options available. For some reason, this isn't showing up, but it's just the Visa Bulletin. You can Google November Visa Bulletin and you can see what those backlogs look like as well. And Ryan, I'm going to turn it over to questions, and I'm happy to discuss any further issues, but look forward to everyone's questions.
Thank you so much, Adam, and
Sure,
absolutely.
absolutely.
Let's just jump right into our Q&A. Explain the meaning of profit and nonprofit schools and how I can become eligible for H1B after graduation. So I guess this is separate questions, but I guess this person is asking profit and nonprofit in a way. I guess whether he wanted to or she wanted to be eligible for OPT or for cap exempt H1B. We're not sure. But Adam, do you?
Yeah, right, right. Yeah, so I mean, it figures in for primarily for H1B cap exemption. There's some other places where that distinction is important. But that's a situation basically where, maybe somebody wants to get around completely lawfully. I mean, it's written right into the law. Wants to get around the H1B lottery and be able to get a cap exempt H1B. It is for uh, institutions of higher education, which are basically nonprofit private universities or public universities, which don't have to be nonprofits, public universities, and it could also be nonprofits that are affiliated with universities, and it could be nonprofit or government research organizations. They're all able to supply the cap exemption. The nonprofit is, it's a 501(c)(3). It's all determined by the IRS, Internal Revenue Service, that basically where you file your taxes. They determine 501(c)(3). And I think it can be some other ones too, maybe 501(c)(3), C4, C6, different types of nonprofit designations that will work for cap exemption. So it's very much defined by tax law.
And if you're not looking at cap exception, if you're looking at a regular H1B, I think the most common way is just to find a employer that actually sponsors that. So once after you graduate, you find a job and that company sponsors your H1B and you will enter the lottery. Hopefully you will be selected and they can process that. Okay, let's go to question number 3. A very good questions. So I'm currently on F1 and I would like to start my own company. Is it possible for me to own a company and then sponsor myself? I guess this sponsorship could be OPT, could be H1B, could be green card. It could be a lot of things.
Yes.
But
Yes.
what's your insight on this?
So yes, yes, and it first off, if we're talking about OPT, is really the most common point where a student entrepreneur starts a business, and that is work authorization that is very easily used for working at your business. Okay, that's post completion OPT, the first 12 months. STEM OPT, it is also possible to have a business there. There are some other considerations that are involved, like employer-employee relationship, like who's going to supervise you. Does the company have is it registered in E-Verify? Are you involved in activities that are directly related to your course of study? So other consideration, I mean, OPT is that way too with the direct relationship piece, but OPT is very open for sole proprietorships, et cetera. Whereas STEM OPT is a bit more discriminating in terms of what types of corporations or what type of structure, business structure is workable. Sole proprietorships don't work as well. And that's a situation where there is no legal distinction between the owner and the entity. Okay. However, if you take a sole proprietorship and you add a board of directors, there is space now. Even though it is sort of the same owner, there is some outside supervisory element. If we get into and maybe this is the direction the person who asked this question is going. If we're talking about something where I'd like to potentially raise some venture capital, that's usually going to be a situation where somebody is incorporating a business, has an outside board of directors, is not considered an owner, or I guess is not considered self-employed. They're a shareholder in the business, and a C corporation, for example, is like the most common corporate structure where somebody could, is putting themselves in the best position to receive venture capital. So that works for STEM OPT, as you can see, sort of that distinction in what the business structure should look like. And it also works in a very similar way with the H1B. It works well where you have that outside board of directors. And so you have that employer-employee control element. So that could be a whole nother session, but
Yeah.
yes, it does work.
Absolutely. Yeah. We recently did do a session with somebody sponsored. I mean, he technically transferred his H1B to his own company and through this legal way that Adam just mentioned. So if you're curious, definitely go to our YouTube channel to check out those episodes. And let's go to next questions. Can you please shed more lights on the 6 years limit, referring to the H1B 6 years?
Okay, so the 6 year limit is so there is a maximum to the H1B. And it's usually done where you have that first 3 years, and then you will then renew for an additional 3 years. And if you have not started a green card process, that's basically the end of it, unless maybe took some trips during those 6 years and you can recapture some of that time, or you actually leave the US for 1 year and you come back to reset. That coming back and resetting is not as great for someone's career in a lot of cases if they wanted to have that career in the US. So what's more common is that an employer will start a green card process. Nowadays, with how long everything takes for the green card, especially the PERM process, which is the most common employment-sponsored green card process, it's best for an employer to start it no later than when they are already getting ready to extend the worker for an additional 3 years. That's a great time to get started, although some employers will start even earlier than that. And the benchmark is to try to file the PERM or file the I-140 if it's another type of green card process before the end of the 5th year of H-1B status, so that that person can get at least 1 year H-1B extensions. But if the I-140 petition gets approved, it allows for 3 year extensions. Especially this is if in a situation where there are green card backlogs and an approved I-140. So you don't have to remember all the details of it, just to understand that it is important to start the green card process. If not before, then maybe around the 3rd or 4th year of H-1B status to be able to hit certain benchmarks that allow for extensions of H-1B.
Absolutely. This is very crucial. And moving on to the next question, is it possible if I register in the lottery with a different employer and file the petition with another employer?
Yeah, it can well, Actually, that's a really good question. Is it possible if I register with a different employer and file in the petition? Okay,
It's in a
so that
time
is not an
when,
advisable. Sorry, Ryan. Go ahead.
yeah, I guess in the time if the later employer wasn't registered for you, you cannot later add that employer into the
Right.
H1B.
Yeah, I think this is more of a situation where somebody, you got to connect the dots between the registration, the selection notice, and then the H-1B that ultimately gets filed. But sometimes it can happen where um, a, a person works for that H-1B employer for a period of time and then transfers elsewhere. Okay, so like they actually get the H-1B filed, they actually start working with that employer, and then ultimately, sometime down the line, they transfer it to another H-1B employer. They're already counted under the cap at that point. So that's the part that's workable,
Mm.
but not what's directly asked in this question.
Yeah, we sometimes see some people come to us that it's very unfortunate that sometimes people get laid off right after they got selected by H1B. And I guess in that case, you won't be able to file with another employer, even if you got the new job, because at the time when you were filing for H1B, the new employer wasn't filing for you.
Yeah, that can be a very difficult circumstance. Depending on like when it happened, it might be possible to get back to the OPT if maybe the H didn't fully go through, and it might be possible to withdraw that H-1B and still retain the OPT, but it's messy. It's a messy type of situation.
Right, right. All right, let's go to next one. What is the involvement of LCA? I guess can we briefly go through what an LCA does?
Sure. So the labor condition application it's basically it's a component that is filed with Department of Labor. So Department of Labor is responsible for basically like protecting uh, American workers, but also protecting other workers from exploitation and just making sure that the proper wages are paid, that a company is not bringing in immigrant labor. If there's a strike and the employer says, well, I don't want to pay those union wages, I'm just going to bring in somebody else to do this job, right? If there's like strikes or layoffs or things of that sort, they don't want employers wielding, immigrant labor and exploiting them in order to avoid paying proper wages to everyone, including American workers. Okay, so this is this is in a nutshell the conditions of the H-1B employment that is sent to Department of Labor. And there are certain attestations the employer needs to make, relevant to what I was indicating. They have to post notice that an H-1B is going to be filed for everyone to be aware of. It has to be posted either electronically to all employees, that and employees of that work site need to be able to access it, or it needs to be posted physically and available for others to see at that work site. And there has to be a public access file, basically a compliance file that is created that anyone in the public can request and can look at that compliance file as well to see what H-1Bs are being filed and the documentation and the wages that were offered. So that's basically what it is. And it's certified pretty quickly by Department of Labor. It's a very cursory review that's given, but there has to be a certified labor condition application that's included with the H-1B petition.
Mhm. Absolutely. And I think we're coming to an end of today's session. To be respectful of everybody's time, we'll do one more questions, the final one.
Sure.
I know we still have a lot coming in, but we're happy to invite Adam once again with us, maybe in a future sessions that we can address those questions. And just a quick reminder, we do these kind of sessions very often. So even if you just, watch the half part of it, feel free to watch the recordings or attend future session with us. All right, final questions. Why some employers cannot sponsor H1B or do not sponsor H1B? I will add that. And who can sponsor a H1B?
Yeah, really, most employers can sponsor an H-1B. There's a regulation for it, but there's very few companies that actually can't, like, aren't eligible to file. You have to have an FEIN number, Federal Employment Identification Number, but really even, or I guess a Social Security number, because even individuals can sponsor H-1Bs in certain cases. You don't see that quite as often. Usually it's companies. And as we already noted, right, a person can set up their own company and sponsor themselves for an H-1B in certain situations. So I don't think that it's really a can't. I would say that some employers, not in most cases anyway, but it does have to be a U.S. entity, so it can't be a foreign entity that is filing the H-1B. And not all employers can file cap exempt H-1Bs, right? But a lot of times, if you're encountering employers who say that, it's because it's their policy. It's an internal policy. I have this a lot of times with clinical trainees, physicians who come in to do their graduate medical education. A lot of academic medical centers will sponsor something called a J1 status, and most of them don't sponsor H1B status. That's an internal policy. They can sponsor H's, but they've chosen not to for a variety of considerations, many of which have nothing to do with immigration at all, in terms of that decision making process. Some are some don't sponsor it also, I guess because of the fees, the costs that need to be paid. Some of it is just lack of awareness of how it works and fear of the unknown. I mean, I guess if you don't really have a skill set for something and you don't know what you don't know, maybe you try to avoid that. But I think that most people that do file H-1Bs, they do it. It's not that employers enjoy filing H-1Bs, right? It's because they need the talent. They need the talent. They're willing to pay the fees and everything, because they want to open up a new pool for labor supply and professional, advanced, sophisticated, talented labor supply, right? There's economic need in various industries in this country.
All right, well put. Thank you so much, Adam. I think this is our final questions, and I want to thank everybody for coming in to today's sessions. And as I mentioned, we will be very happy to invite Adam once again with us to do another session. So definitely stay tuned for that. And thank you, everyone, and happy early Thanksgiving to everyone. And thank you, Adam, for coming in to deliver this wonderful presentation.
Thanks, Ryan. Happy Thanksgiving, everyone.
Thank you. Thank you. Bye bye, everyone.